Good morning again. This is the House Appropriations Committee. It's Thursday, March 12th, 2026, 10:10 a.m. We're back to talk about the landlord tenant bill, H 772. As I mentioned, we're going to hear from Legislative Counsel first, and then our Joint Fiscal Office, and then we'll hear from the chair of the committee and reporter of the bill about it as well. And what I want you to know is that there's a good portion of this that relates to judiciary. And so the House Judiciary Committee, who is not taking possession of the bill, is working on that, and we will have an amendment to that part of it. So what you'll see today in that section, even though we go over it, a bunch of it is going to change. I spoke with the chair yesterday. They've taken some testimony. He's still going to be talking to the court administrator. His plan at this point is to come in and talk to us on Wednesday morning about that section. So what we hear, listen to it. You don't have to absorb all of the judiciary part, but I felt this was important that we hear the bill, have time to think about it, ask questions, learn more, and at least understand all the rest of it as best we can before we come back and hear about the judiciary side of it. So we will not be voting on this bill this week. It'll be sometime next. Okay. Then we'll see where we go from there. All right, so I'm going to turn it over to Cameron from Legislative Counsel.
Morning. Cameron Wood, Office of Legislative Counsel. I'm just trying to share my screen. Okay, what I am looking at is 772, the report that came out of the Committee on General and Housing. So the recommendation from that committee.
Is that draft 4.1?
Yes, ma'am.
Okay.
And so as you mentioned, this has also been a lot of discussion in the Judiciary Committee as well, and they were reviewing a proposed amendment to this report just yesterday afternoon, and I'd be happy to have any comments or try to briefly discuss that as well if the committee would like. But for now, I'll just kind of keep to this report as it came out of the General and Housing Committee. Given your time and given the depth of this bill, I'm going to just walk through the sections and kind of mention what each section does, and I'm not going to do a line-by-line review, if that's okay.
That's perfect. Be getting more at the high level.
Perfect. Okay. So the bill deals with the landlord-tenant relationship, and there are two things to keep in mind. First, you have in Title IX a chapter about residential rental agreements, which governs the agreements between landlord and tenant, obligations of tenants, obligations of landlords. But then it also addresses what happens when you need to terminate the rental agreement between those two parties. And it talks about what is the time frame which the landlord has to provide notice to a tenant if the landlord is going to terminate the agreement. Now, there's a lot of changes in the residential rental agreement chapter that I'll walk through, but a lot of them deal with this termination notice period and both shortening in some instances and lengthening in others, the period that has to be provided to the tenant if the landlord terminates. Next, we go to, there are changes regarding ejectments. And so you have a residential rental agreement that gets terminated, but what happens if the tenant remains in the location after the date of termination of the rental agreement? The landlord then has to bring an ejectment action in court to then receive a writ, what's called a writ of possession, to then have that individual potentially removed from the property. And so a lot of the bill addresses the first piece, the rental agreement between the landlord and the tenant. And then there's another pretty large section of the bill or chunk of the bill that deals with the ejectment process. And then at the very end, there's a section about a credit reporting program. So I'm just trying to kind of bucket your thoughts right out of the gate.
Okay. Did you have a question, Wayne?
Is there any big difference in the ejectment process between what it is now and what this is?
There is a proposal in this bill to create a new subchapter with a new ejectment process for certain ejectments. So ejectments based on a limited type of termination. And I would say, I think the intent or the goal is to try to make that a faster process.
So we'll get to that, the second bucket.
Okay, so the first piece here is dealing, as I said, with the residential rental agreements. We have some changes to the definition of actual notice. So in order to move forward with a termination, landlord has to provide actual notice to the tenant. And so there's some alterations to what the definition of actual notice means. It would authorize delivery from sheriff's service. It would authorize the notice to be emailed and mailed. So currently it has to be either hand delivered or mailed. This is saying you could do it by sheriff's service. You can mail it and email it. And then moving to the top of page 2, it's saying if the last known address is unknown, then you can post it to the door of the dwelling unit. And then it's altering, there is a presumption that's created that an individual receives the notice 3 days after it is mailed. And there's some alteration there to extend that to 5 days after it's mailed. There was some concern about, the current postal service and delays, et cetera. So there's an extension of that date from 3 to 5. And adding, as you're adding the ability to email and you're adding the ability to post it to the door, you're adding those two things into the presumption as well. There's a definition of immediate family, and I'm not gonna walk this line by line. I'm gonna somewhat pass over it and come back to it later on because it has an impact when it comes to a termination for a specific reason. If you want an immediate family member to take over the apartment or the location. So there's a definition of immediate family being added here. And I'll just comment, it's pretty expansive, the definition. Okay, so then a few additions or alterations to the residential rental agreements subchapter. The first one is regarding rent increases. So we're moving to page 3. This is saying that a landlord cannot increase rent more than once in a 12-month period. That shall not prohibit a landlord from increasing rent after the purchase of a dwelling unit. So if you're a landlord and you continuously own the property, you can only raise rent once in any 12-month period. However, if you purchase a building, so now you're a new landlord, even if that previous landlord had raised rent within that 12-month period prior, you can raise rent at that point when you purchase the building. Then we get to residential rental applications. So current statute says that a landlord cannot charge an application fee in order to submit a residential rental application. That term is not defined. So there's been a lot of discussion in the committee about, well, what is an application fee? Does that include background checks or credit checks? And there's been concern about landlords charging fees, even though the statute prohibits it. So there's some language here to expand on this section. Application fee means any fee, charge, or cost to submit the application, including a processing payment. And then in the sub 3, it states that the landlord may charge actual costs to conduct a background or a credit check unless the tenant provides a current credit report, and then they cannot charge for that. And then the current credit report is within 90 days prior to the application. So if you provide them a copy of the credit report that has been pulled within 90 days before you apply, you can't charge for it. If the landlord charges for the background or the credit check, then the landlord has to give a copy to the tenant. And then the last piece here.
Yeah, good question. So I understand that it can cost anywhere between $1 and $40 for a credit check. I don't know what a background check costs, but do they have, would they have to, if they charge for it, do they have to actually produce the receipt so that they're not charged $40 for something that costs $2?
There's nothing in the statute or the new language that would require the landlord to provide to the tenant what the actual cost was. It just says they can only charge for the actual cost. I think a key thing here is this new subsection C, which makes violations of that section an unfair practice in commerce. And so that gives the attorney general or a state's attorney the authority to investigate. It also gives a private right of action to an individual who has been harmed. So if there was a concern or there was frequent complaint to the attorney general's office that a landlord is overcharging or charging and not conducting the background check, the attorney general's office could investigate it at that point. But the direct answer to your question is no.
Yes, thank you.
There's no receipt that has to be given. Yes.
Yeah, thank you. When you do a credit check or a background check, it doesn't say anything about permission from the tenant. That require,
There is language that was added last year that talks about what a landlord can and cannot ask for from the tenant in order to conduct a background check. The landlord can request a government issued identification, the social security number, or the individual's taxpayer identification number if the individual doesn't have a social security number. But the tenant isn't obligated to give any of them. They can give one of them. So if you, what I mean by that is if you tenant don't want to give the landlord your social security number, you're not required to. You can give them your ID, and then they would have to do the background check based on that identification.
how do you do that without a social security number?
The committee took testimony that it is possible to do a background check with name, first name, last known address. It may not be as complete. It may not be as comprehensive as doing a background check or a credit check based on a social security number, but it is at least possible to do one.
Yes, okay, good.
Oh, Tom. And under this, the way this is written, this is separating out an application fee from a background or credit check. Is not a background check or a credit check part of the application? A requirement for application.
I think it could be.
So, I mean, if I'm going to rent, that agent or that landlord is going to require me to fill out an application, which is fine. But if it's a requirement to have a background check or a credit check, is that not part of an application? Should that not be considered, or can that not be considered part of the application?
I think that's
your name, address, social security number for the purpose.
I think that's a question under the current statute. Like the current statutory language just says that a landlord shall not charge an application fee. And there was conversation among the committee members about, is that if you're charging for a background check or a credit check, isn't that just part of the application? Exactly the question that you're asking, sir. And the decision of the committee with this language was to say, we are going to not consider those two things an application fee. So a landlord can charge for that at the point of application. Or
You can't charge a separate application fee just for filling out the application.
correct. So you could say, here's the application. I'm going to run a credit and background check for you, and it costs this much to do so. And your application won't be considered unless you pay for it.
It says may charge actual cost to conduct a background check. It doesn't say you have to. It doesn't say you have to charge for background credit check. It says may.
It's a may, not a shall.
But nevertheless,
May do it as a landlord without charging anybody anything. Just do it. Just get the permission or get the name or the information.
I know, I understand that. It's nevertheless, if it's a requirement of, I mean, I'm not expressing an opinion, I'm just asking the question that is really a deep rub, which is if it's a requirement and a fee is charged, again, it has been considered an application fee. So what you're saying is that the committee chose to split a hair here in verbiage.
I would say, yes, sir. They've determined that to charge for a background or a credit check is not an application fee under this language.
It's not explicit in the language, so if someone has to go to court, a judge could interpret that in a different way, right?
Interpret what a different way.
You could write into that language that explicitly that the credit check and the background check are not part of the act. You could put language in for that, and if you leave it silent right now, in a court of law, a judge might make a different decision.
I think the language written is pretty clear. It's a policy question of whether you want to authorize a landlord to charge for something like a background or a credit check. And if you don't, if you think that that could, be a barrier to individuals to applying, then you could take out the sub 3 and you could say in the sub 2, as used in this section, an application fee means any fee, charge, or cost, including background check or credit check.
I'm not suggesting any changes. I'm just suggesting that it might be clearer if you specifically said that this is not part of the application.
I think it's probably a question of semantics, and this is the legal language that does it, and he's our lawyer.
Yeah, I think the language is okay. I mean, it's, you have the prohibition, we're defining what an application fee means, but then within the same subsection, we're saying that a landlord can't charge this. So you're given the legal authorization for them to do so.
I understand.
And we understand you might have written it differently.
See, I'm looking at the flip side. Say you charge the fee or something, and I went to court and say this guy shouldn't have charged that fee because it was part of the application fee. And then the judge would look at this language and he'd decide whether it was or not, was not part of the application fee. Because it's not explicit, he could rule that it was.
But I think it is explicit because the sub 3, a judge is going to look at it and say a landlord may charge actual costs to do it. So you've given specific statutory authorization for them to do so.
We're going to need to move on. This is for us to understand it. We don't have all day for this one, even though we could. So let's.
Okay, I'm going to move you to page 4. The next section is in security deposits. And what this would do is put a cap, a statutory cap on what a landlord can charge for a security deposit at an amount of 2 months rent in addition to the first month paid. Currently, there is no statutory cap, so a landlord can charge whatever the landlord wants for security deposit. So this will put a 2-month cap on that. And then the sub 3 is saying that separate from that 2-month cap, a landlord can charge a separate security deposit in order to allow a tenant to have a pet. But a landlord shall not charge any amount for an animal that mitigates a disability. So you can charge a separate security deposit for pet deposit. Then moving into the sub 2 down here, what this section subdivision is saying is if a landlord is, there's this concept that is kind of floated around. It's not necessarily written in this language, but there's this concept that termination can be based on 2 things. It can be based on cause, if the tenant is giving cause to terminate. The tenant's not paying rent, the tenant's breaching the terms of the rental agreement, etc. Or a landlord can terminate based on things like the lease expired, the lease is up and I don't want to renew, right? Things that are not really within the control of the tenant, they're more in control of the landlord. What this section is saying is if the landlord is going to terminate for one of the latter reasons, so it's not for cause, it's not because the tenant has done something, it's because the landlord is choosing not to renew the rental agreement or because the landlord needs to terminate because they're repurposing the building or I'll get to the language here in a second, then the landlord has to give half of the security deposit back to the tenant 45 days before the termination notice. So essentially what this means is if you're not renewing the rental agreement with the individual, you have to provide the individual later on down the road. It's extended to 90 days. The statute, this recommendation extends it to 90 days notice. At the 45-day mark, you have to give that individual half of their security deposit back. Okay. Let's see, we're moving to the next section, retaliatory conduct prohibited. So this is a prohibition on conduct of the landlord. The landlord can't retaliate against a tenant for things that the tenant does, such as complaining of health and safety violations, et cetera. You can't retaliate against a tenant for doing that. And there's language here adding that the tenant has taken any legal action authorized by law against the landlord. This was to address concerns where the landlord may be harassing or, threatening the tenant directly. And if the tenant goes and, files a police report associated with that or something in that regard, then the landlord can't retaliate against the individual by terminating the rental agreement. Moving on to the next section, which is on page 7. Okay, we're on the termination of tenancy. So this is where a lot of the changes are. As I mentioned in the very beginning, you have the requirement of a landlord to terminate a rental agreement before you even get to bring an ejectment action. You have to terminate the agreement with the tenant. And that's what this 4467, this section, is dealing with. What are the notice periods required for termination of a rental agreement based on what scenarios exist? And so what sub A is as it is right there in the heading on line 5, termination for non-payment of rent. If the landlord's terminating for non-payment of rent, the proposal here is to shorten that notice period from 14 days to 10 days. Moving to the next section.
Yes, question.
2 questions, 10 business days or 10 calendar days?
It will be calendar days.
And this is for a rental agreement. There's the real world situation tends to be there's very limited number of leases that are done, or a lot of cases where a lease is signed for a primary year, and then in years following, months and years following, it tends to be a verbal lease. Just under a verbal lease, do tenants know? Like, I can go look at a contract, but in year 2, that contract that's written is not really, it's not written, so it's not viable because there might be a different, verbal agreement isn't as complete as a contract. So are we talking about both leases and handshake rental agreements here?
Yes, sir. So to the point there's nothing in the statute that requires a written rental agreement to be in writing. So I think the scenario you've outlined is probably very frequent, where you begin a rental agreement with the landlord and the first 12 months is in writing, and then subsequently nobody bothers to renew the written agreement, and then you kind of go to month, essentially, is kind of conceptually how that would work. But it's not required to be in writing. So you could begin the rental agreement based on a verbal handshake, and the sub A here would apply to either of those scenarios. If you've agreed to a rent amount on a day, and the question would become if you're going to terminate the rental agreement because the individual has failed to pay on the day that has agreed. If you have the written agreement, you can all point to it and say, we agreed to it, here's what it is. It's less ambiguous, but in a verbal agreement, the parties would have to prove that in court.
So can you clarify then the 90 days notice on a month-to-month lease? I think there's a disconnect between those two things. It makes perfect sense on a contract that has a date certain to end. But can you just explain to us the legal reasonings of 36 to 90 days when there's a month-to-month lease?
So currently, the way the statutory framework is structured, there are separate subsections that deal with, do you have a written rental agreement? Do you not have a written rental agreement? The next question is, have you been there for 2 years or less, or have you been there for more than 2 years? And the termination notice periods currently is going to be dependent on those 2 questions. If you have a written rental agreement, and you've lived there for less than 2 years, you have to provide 30 days notice before the end of the written rental agreement term if you're going to terminate at that point. If you've been there for greater than 2 years, you have to provide 60 days notice before the end of the rental agreement term. If there is no written rental agreement, then the landlord can terminate at any point with 60 days notice if you've been there for 2 years or less, or 90 days notice if you've been there for more than 2 years. So all going to depend on those circumstances. Is it written? Is it not? How long have you been there? What this proposal does further on down is it gets rid of all of those distinctions, and it says whether you have a written agreement or not, whether you've been there for 2 years or more, it's 90 days for all of those. So if it's in writing, it would be 90 days before the end of the written term. If there is no written rental agreement, then it's 90 days. So that's how this bill addresses the distinction between the written and non-written agreement. Okay. So then we get, so again, A, non-payment of rent. B is for termination for breach of a rental agreement. So under the B1 on line 16, this is adding in that the landlord can terminate a tenancy for current statute is failure to comply with material terms or obligations imposed under the chapter. This is adding in more provisions to say that a landlord can terminate for breach of a rental agreement if the tenant is late payment of rent more than 3 times in a 12-month period. The tenant's refusal to allow the landlord or the landlord's agents access to the dwelling unit as required. And then it's reducing the termination period for that subset of reasons from 30 to 21 days. And then late payment is defined as payment more than 10 days after it's due. So then you get into the sub 2. We're still under breach of the rental agreement terms. There's some change in the language here. I think the key things to focus on are going to be on lines 9 here that I've highlighted. It's if termination is based on acts which threaten the health or safety of other residents, the landlord's agents, or the neighbors, then the landlord can terminate the rental agreement, and then it's being shortened from 14 days to 5 days. The new B and 3 here is stating that the notice that's provided, if the termination is under this subsection B, the notice that's being given to the tenant has to include an affidavit that sets forth particular facts describing the events that are leading to the termination. And then sub 3 is the landlord shall not terminate a rental agreement under this subsection based on a person seeking medical assistance for a drug overdose, being the subject of a good faith request for medical assistance, or being at the scene of a drug overdose within close proximity to a drug overdose. So there's a separate section in law that you all have enacted, which is kind of a good Samaritan provision, if you will, and it states that individuals cannot be criminally liable if they are seeking medical assistance from a drug overdose, subject of a good faith request for medical assistance for a drug overdose, or being at the scene of a drug overdose. You've given certain exemptions from criminal liability for people who are seeking medical assistance for those reasons. And so what that section is doing is saying you landlord can't terminate somebody's agreement because they have sought medical assistance because of a drug overdose.
So it isn't drugs the same way, like it's not the same as selling drugs. It can't be accused of, yeah, okay.
Okay, so the remainder of this section, there's a lot of additions and strike throughs. It's a lot of consolidation of the current subdivisions regarding termination of rental agreements. So what sub C is now going to refer, it's termination for the tenant's notice or for government notice to vacate. And it states that when termination is based on the intent to vacate provided by the tenant, then the landlord can terminate the agreement on the date provided by the tenant. And then the sub 2 is if termination is based on an order issued by a government agency, then the landlord can terminate based on the date provided in the order from the government agency. Now we get to termination when a property is sold or repurposed. So this is current statute that if the landlord contracts to sell the building, the landlord can terminate the tenancy for 30 days. That's being extended to 90 days. And then adding a few other sections that kind of fall under this quote repurposing of the building. So you've contracted to sell the building. You want a member of your immediate family to move into the building. That's where that definition of immediate family comes in. You're permanently withdrawing the dwelling unit from the rental market, or you need to demolish or refurbish the building. Any of those circumstances, you can terminate the rental agreement, but it's 90 days instead of 30 days. And then when we get to subsection E, moving to the top of page 11, this is what we were just referring to, Representative Stevens, as we were talking. This is a kind of consolidation to say, whether you have a written agreement or not, it's going to be 90 days consistent, as opposed to this distinction between written, non-written, 2 years or less, 2 years or more. So it's 90 days across the board, and it's 90 days before the expiration of the written agreement, or 90 days in the event there is no written agreement. And then we have, if it is week to week, there was testimony that there are some week to week contracts that still exist. It's extending it from 7 to 10 days. And then moving forward to sub H on bottom of page 11, if it's a shared occupancy, currently it depends on whether it's a monthly or weekly. And there's consolidation here to just say if it's shared occupancy in sub H, it's going to be 7 days on the top of page 12. Okay, I'm going to keep moving unless somebody stops me. There's some statutory cleanup on page 12, the bottom, payment after termination. This really doesn't have any substantive effect. It's saying that if a landlord accepts payment for anything other than the non-payment of rent, so if you're terminating an agreement for anything other than that, and you accept payment of rent, that is not you agreeing to forego your termination. You can still move forward with termination of the agreement, even though you're accepting the rent from the individual. That's what this section is for. Okay, now we're on page 13, this new subsection here. Currently, there's a separate section that allows a tenant to not pay rent if there are issues with the unit. There are kind of serious health safety violations of the unit. The tenant has a statutory ability to not pay rent at that point in time. And what this section is being included is just to further add in that if a landlord brings an ejectment action due to you not paying rent, it is an affirmative defense to that ejectment, and the judge shall rule in favor of the defendant if there is a serious health and safety violation. That the landlord, key language here is going to be on lines 14, the landlord has made no reasonable attempt to correct. So if the landlord's made aware of it, they've been issued a citation, you have a healthy violation, and you're not doing anything to fix it, the tenant doesn't have to pay rent, and it's a defense if the landlord brings an ejectment action against you. Okay. This section here, 4468, is stating that if the tenant remains in possession after termination of the agreement, the landlord can bring an action for removal of that individual. And this is just adding in some change to the language right here in the sub 1, because there is a new subchapter 4 that's being created later on. So this is really more just technical cross-referencing. Now we're on page 15. Okay, now we're getting out of the residential rental agreement section. We're moving into ejectment. So individual has stayed beyond the termination date. Now the landlord is going to bring an ejectment action against the individual. This first section 2 is stating that for any civil action, if the court orders an alternate service of process, then that alternate service of process would exist throughout the life of the case. What does that mean? If you bring a civil case against somebody and you can't have them served, you can ask the court to provide an alternate service, which could be a tack order, for example. You tack it onto the individual's door. Currently, you have to go ask the court every time you need to serve somebody papers throughout the court case. You have to ask if you can get a tack order. What this section would do is it says, if you ask once and the court grants it, it applies throughout the case. You don't have to ask multiple times. I will say that the Judiciary Committee is reviewing a proposed amendment to strike this. Okay, I'm going to keep moving.
Getting into a bunch of stuff that may be changed by judiciary, right?
Yes, ma'am. And so,
Let's
I could be
understand
even
it
further
enough,
high
but like,
level.
we don't need to get into all the details of what we like and don't like until we hear from
I will be a little bit even kind of further high level here through these sections then. When you look at page 17, this is under the current ejectment chapter or subchapter. A landlord can ask that a tenant pay rent into court during the ejectment case that's being brought. So during the life of the case, you tenant need to pay rent into court. Currently, that can be either full or partial payment, and this proposal strikes partial, so it would require full. So currently, your rent that you owe is $1,500 a month. Landlord asks for it to be paid into court. The judge can say yes, $1,500 into court, or they could do less than that. And this is removing that discretion and saying it's only $1,500. It would have to be all or nothing. So that's what the change on page 17, line 2, and then subsequently striking subsection G is where the tenant can by motion apply to have a reduced amount, and that's being struck. Next is 4854A, property of the tenant remaining after eviction. This is changing or reducing the time frame that a landlord has to maintain the property of an individual after a writ of possession is issued. So you go to court, you get the ejectment, the court orders, yes, landlord, you're entitled to the property. Here's your writ of possession. That writ has to be served by a sheriff onto the individual. And then the sheriff cannot remove the individual until 14 days has passed. That's in separate section, separate language. Once the sheriff has removed the individual from the property, the landlord currently has to maintain that property for another 15 days. They have to maintain the property of the tenant that's left behind for another 15 days after that. So it's a total of 29 days when you look at both of those timeframes. This gets rid of the second half of that piece and just goes, sheriff issues the writ of possession, can wait 14 days before the sheriff actually physically removes the person from the property. At the point the landlord gets possession of the property again, the landlord can get rid of all of your stuff that stayed behind. Okay, moving into this subchapter 4. So this is starting on lines 14 of page 19. Currently, there is a Superior Court ejectment process. What this subchapter 4 is saying is operative words here on line 9. If it's for termination based on either non-payment of rent or the breach of the rental agreement. So non-payment or you're not complying with your obligations.
Right, the
I'm on
19, line
page-
19, not
Line
9.
19, bottom of page 18.
Okay, sorry.
Excuse me.
Thank you.
So if it's for termination of one of those reasons, you're not paying rent or because the tenant has breached the terms of the agreement or is threatening, doing some action that threatens the health and safety of other people, then the landlord can bring an ejectment based on this new subchapter. And so there's a lot of language in here about the mode and service of that process in 4862. The answer period under 4863. And then moving forward on page 20, what a default is, and then this show cause hearing at the bottom of page 20 under section 4865. What I'll say about all of this is shortening the current process pretty significantly for ejectment cases. So for example, in the answer section, 4863, it says that the defendant has 14 days to file an answer. Well, current rules of civil procedure are 21 days, so it's shortening that time frame. And so I'm simply saying it's creating this new process. It's creating shorter timeframes to move through the ejectment process based on if you're bringing the ejectment due to non-payment of rent or breach of material terms. And I will say that the proposal that's being reviewed by the Judiciary Committee is removing a significant portion of these provisions and making it consistent with what the current civil rules of civil procedure require and what the current ejectment process looks like.
Clarification, so, but one can't be ejected for, late payment, until you've been late 3 times in a 12-month period.
Yes, ma'am.
Okay.
Under the breach of the material terms, currently the statute's silent about that. If you're late payment, if you pay late, what does that mean?
Right.
And so this is adding in that if you are 10 days, if you pay for rent 10 days after it's due 3 times within a 12-month period, a landlord can can terminate the rental agreement based on that, and then subsequently bring an ejectment action. Okay, so I'm going to bring you back to page 22. Everything leading up between what we're just reviewing, pages 18, 19, 20, 21, 22, that was all the language about the new ejectment process, which is intended to be faster. And so page 22, we're going to transition over and talk about trespass. So the top of this, page 4868, is if the landlord is restored to possession of the dwelling unit, the landlord can give a no trespass order against the tenant who has just been ejected. And then you move into these next 2 sections. There's a purpose statement here. And it states that the purpose of section 5 is to overrule Vermont Supreme Court decision in State v. Dixon. Yes, ma'am.
We can overrule a
Yes.
Supreme Court decision. I'm sorry.
No, it's okay. Yes, because the Supreme Court's decision was based on a statutory interpretation. It was not based on some sort of constitutional right. And the question at issue in the court was if a landlord, gives a no trespass order against someone, but the individual is in the common areas of a location and they're on their way to a private individual's residence who lives there and they've been invited to that place, then the court ruled that the statute didn't allow the police to give him a trespass citation because the individual was in the common area and they had been invited to a location that an individual had legal right to possess. And so it was more of a statutory technical issue. It wasn't based on some sort of constitutional right. So that's why this is saying the intent of this next section is to overrule that decision and make it such that, and let me get to the key language is going to be on the bottom of page 22 and the top of page 23. The landlord of a dwelling unit may cause to be served an order against trespass that prohibits a tenant's invitee or licensee from trespassing in the dwelling unit or the dwelling unit's common areas if the tenant responsible for the invitee consents to the order, the invitee subject to the order is violating the terms of the lease agreement, or the invitee is violating state or federal law while on the premises. So it's adding in this specific statutory language, signaling to the court that this is intended to alter the decision that you made in this case, State v. Dixon.
So are you saying this is reinterpreting or rejecting the interpretation of the Supreme Court?
It is, I don't want to say it's rejecting what the Supreme Court has issued because it's not changing the statutory language that the Supreme Court based its decision on. It's saying that essentially, notwithstanding that case that you issued, we disagree with it, and we're adding statutory language here to make it such that if the same case comes before you under those similar facts, based on this new statutory language, the trespass order would be upheld. And I'd be happy to talk offline.
Sure. That would be great. Thank you.
Sub 2 here adds an appeal process for that. I will say that the Judiciary Committee has reviewed possibly striking the appeal process. There is no appeal for a current trespass order, so there was discussion about why would there need to be an appeal for this. So there's proposal to remove that. And then there's just definitions of the dwelling unit and the tenant, which refer back to the definitions in the residential rental agreement section. Moving to page 24, these next few sections are about confidentiality of ejectment records. I'm not going to walk through the definitions, so I'm going to bring you to page 25 under the section 4872 and 4873. All records that are newly filed for an ejectment complaint have to be confidential, and they're designated confidential they're documents that are under the control of the judiciary for an ejectment case. And then the section 4873 is if the court finds judgment in favor of the landlord for an ejectment case that's brought for non-payment of rent or for breach of the terms of a rental agreement. So only under those two scenarios, if the landlord wins the ejectment case and is given a writ of possession, then the court would remove the confidential status of the case 30 days, presumably 30 days after the judgment was issued.
I think this is an area that Chair Lalonde was concerned about and working on. So this might change.
Yes, ma'am. The proposed amendment that they reviewed yesterday already makes some changes to this, and there was further discussion about possibly making further amendments. So I'll just say that this entire piece here is to say if an ejectment action is filed, it's going to be made confidential. And then if the landlord wins because of a termination due to non-payment of rent or breach of material terms of the rental agreement, and the landlord gets possession, then the case kind of loses its confidential status at that point. This is different than expungement or sealing. So there are some kind of legal issues that the Judiciary Committee is trying to work through. Okay. I'm going to bring you to page 27. This is a pilot program that was discussed and was in a few bills last year, moving back and forth between the House and the Senate. It is a rental payment pilot program that would be administered by the State Treasurer's Office. And as opposed to walking through line by line, section by section, I'll just mention that it is the Treasurer's Office would work with a third party and they would engage with landlords and tenants to provide the fact that the tenant is paying rent to the landlord, report that information to credit reporting entities to try to help improve the tenant's credit score throughout the pilot program. The body, the General Assembly, asked the Treasurer's Office to study this a few years ago, and they came back with a report recommending a pilot program to see what the outcomes would be. And so that was, as I mentioned, in some of the bills last year. And so it's here again, hasn't changed from what it was previously. And so again, I'm not going to go through line by line of this, but it's just, how the program is set up, contracting with landlords, what information has to be provided to the tenant, how a tenant can withdraw. If the tenant is failing to pay the rent as required, they can be removed from the program. The Treasurer's Office has the ability to cease the program at any point in time. And so then the There has to be reports back to you all in this draft, November 1 of 2028, interim report, and then a final report submitted in 2029. This is on the bottom of page 30 and top of page 31, the information that the report needs to include.
You mentioned that this has been discussed before. That's what you said. Has it ever been formally proposed and either passed or rejected before?
Yes, ma'am. This similar language was in the Senate and House versions of the housing bills last year in different iterations, and then it was kind of, improved upon. And I don't recall last year at what point it was dropped. It does come with a requested appropriation. And the treasurer's office, testified last year, without the money to administer the pilot, they can't administer it. And so, again, I just don't recall at what point it was dropped, but it was discussed in both the House and the Senate, and it did pass bodies at one point in time. But
Okay, but it was never actually enacted
Amen.
or never voted on and rejected.
I'm guessing it. I gather the money was the issue.
The money was
That's
the
my
issue.
guess.
Okay.
Yeah.
I just have it's a technical question. I guess there are certain parts of the bill where we say landlords and other parts of the bill where we say property owners. And I'm just wondering, are they one and the same? Should they be uniform or? Because in this section it says property owners and. Anyway, I raise it as a question.
okay, let me take a look at it and do a search of the different terms and make sure there isn't an issue. Okay, so then we get to the bottom of page 31. There is a transition period regarding security deposits. So as mentioned, at the beginning of the bill, there is a cap on what a landlord can charge for a security deposit. And so this section is saying that if a landlord has requested and received a security deposit that exceeds that cap, then the landlord can maintain that security deposit until the end of the rental.
Because it was already in effect.
It was already requested and received.
Just for clarification, equal to 2 months, security deposit that exceeds the amount of 2 months rent. The common phrase that people have is first lapse security. This is saying that first lapse security is still the status quo, that capping it at 3 months, which is the standard, as opposed to people who may have been charging more than that. But the standard, I think everyone can remember signing a lease would say first, last, and security. And I just want to make that sure that's clear, because that's still a lot of money.
Yes, sir. And that's how the cap reads above. It is 2 months rent. You can't charge more than 2 months rent on top of the first month rent that you're paying. I mean, the tenant is paying for the first month to live there. So, I wouldn't consider that as part of a security deposit, because the landlord isn't retaining that money. It's for your first month to be there. But yes, sir, it is a lot of money. I mean, it's 3 months equivalent of whatever that amount is having to be paid at the beginning. And so there was discussion in the committee about what the cap should be: 3 months, 2 months, 1 month. And they settled on 2 months above the first month's rent.
And we have the research done like neighboring states where I know changes have been made.
Not from me. I did not present anything. I don't know if the committee heard any direct testimony about what other states have done in that regard. I did not provide any testimony to that. And I have not done that research, but I'd be happy. Okay, top of page 32. There's a requirement that CVOEO, Champlain Valley Office of Economic Opportunity, provide education and technical assistance to both landlords and tenants. This can be kind of an expansion on their current programs that exist, but then in the sub 2, specifically providing some curriculum and support for landlords. And then you get to the appropriations section. So fiscal year 27. $100,000 to the state treasurer for contracting and administrative costs necessary for the pilot program that we reviewed. And then moving to page 33, $600,000 to DCF to be granted to community action agencies to be used to support liaison work with landlords and tenants. 1.2 million to DHCD for the following purposes. 1 million to Vermont State Housing Authority for the Rent Arrears Assistance Fund, and 200,000 to Champlain Opportunity for the landlord tenant education program that I mentioned in the section above. And then effective date, 2026.
Thank you. Thank you very much, Cameron. Feel free to stay there, but I'm going to ask Ted to come up for the fiscal report. And today. So now it's up to date.
Barnett, Joint Fiscal Office. It feels like pretty much everything at this time of legislative session is dated today, based on where we are.
That's right.
So there we are. I'm not able to share. Yeah. It may not be necessary. I'm simply going to review the appropriations and some context I received from the Vermont judiciary. Let's see. There we are. So put together a table. Cameron walked you through the various appropriations in the bill. Adding them up, they total $1.9 million. There's $100,000 to the state treasurer for the positive rental payment credit reporting pilot program. We'll note right there are a series of reports for that pilot program. And if the treasurer feels that that program is successful, it's possible and or likely that the treasurer would come back and ask for more money from y'all to implement a program at full scale. So I want to flag that as a future consideration. There's an appropriation to the Department of Children and Families they will then grant it to community action agencies to support liaison work between tenants and landlords. DHCD has 2 appropriations that will be granted. One will be granted to the Vermont State Housing Authority for Rent Arrears Assistance Fund, that's $1 million. And then granted to CBOEO for the landlord tenant education work that's outlined in section 9 of the bill.
So of those, Ted, how many of those are assumed to be base, or is it all assumed to be one time?
As far as I understand, these are all one-time appropriations. I believe the Rent Arrears Assistance Fund last received money in Act 181 of 2024. And so that program is going down towards the end of their funding. So they're looking for essentially a top-up a program.
And then there's more.
There's more. I checked in, I will admit, I am not an expert by any means on judicial proceedings and how they operate. And so I reached out to the Vermont judiciary. This is entirely their information based on their reading of the bill and how it came out. House General on Housing, they indicated that because of the confidentiality provisions in the bill and expedited hearings, in order to maintain the current scheduling of the judiciary, they would need more positions, right? So the additional confidentiality proceedings, expediting hearings would take judicial resources away from the rest of the cases on the docket of the civil division, which could delay other cases that aren't evictment or ejectment proceedings. So in order to staff up and ensure that they were meeting the additional requirements for timelines and hearing types in the bill, and also maintaining the scheduling within the rest of the docket, they would need $730,000 per year, and that's additional judges, additional court staff in various corners of the state.
This is part of what Chair Lalonde is talking to the court administrator about. The choices at the moment appear to be, don't give them more resources and increase the court backlog, which we've been trying to reduce. And he'll be more eloquent than I am on this when he comes and speaks, or give them some resources so that we don't go backwards while we're trying to do this other stuff. But there's more conversations about it to come. Tom and then Lynn.
And again, I understand we're gonna be hearing from the legal side. I mean, obviously the changes in due process and the timing is pretty stressful for individuals to understand, especially in the short term. Was there any conversation either in the committee or through JFO, like what potential outcomes towards homelessness would be, for instance? I mean, I can see where landlords need to get people out of apartments on an emergency basis. I see that as a strong point to talk about. But I can also see this being abused in a way, much the same way that the no-cause eviction stuff was used post-COVID. And there was a gross increase in homelessness, which is also an expense. And we've heard testimony about all the different agencies that are dealing with people who are going to experience homelessness. We know that homelessness can come forward through non-payment of rent and a difficult economy. So I'm just curious if there's been any ballpark figures anticipating increases in evictions that may lead into homelessness, and what that effect would be on our human services budgets.
Sure. So I did in my conversations, which were really emails with the Vermont judiciary, I did try and understand whether there would be a change in filings, or like the change in the number of ejectment proceedings. As far as I understand, they did not forecast and see a change in the number, because that would be a primary impact on state revenues, right? If for whatever reason the changes in the bill change the number of filings, right, they pay court fees. So I wanted to understand that primary impact. And as far as I understand in conversations with Cameron too, there's not really an envisioned change in the number of actual proceedings. That said, it's really hard to understand how landlords might respond to provisions in the bill, and whether that would result in more homelessness. I will say those would fall into more of the like secondary behavioral response categories that JFOs, because it's so hard, because it requires a number of assumptions, we typically don't forecast those levels of secondary impacts. So all that to say, it was not considered in the scope of this fiscal note, but I'm not ruling it out.
Lynn, then John.
Yeah, thank you. You want to say something?
I was gonna add, I know Leland has made that concern or commented that concern in the committee, at least in the small bits that I was able to listen or be there for. But as far as how much of the committee discussion focused around that, I would defer to the chair. So I wasn't there for all of it.
Okay, thank you. If I heard correctly, the rent arrears assistance fund was in Act 181 and is now expiring. Is that correct?
It's the fund itself is not expiring. So the fund was originally created here in Act 47, which is the housing bill before the year prior to Act 181. So it's created there. It received its most recent appropriation, as far as I could tell. I'm on the revenue team and I don't always track down appropriations, but the best I can figure is that it last received money in Act 181 of 2024, and that funding is towards they're close to running out of funding. And so, yes, the fund itself may live on, but they may not have the resources to do it.
But they have done this for the past couple of years anyway. Okay, what is the success rate of this? I mean, did people actually, after the arrears assistance happened, did it actually go and have people maintain their residence in the apartment, or did they still get behind after it was over and then eventually get evicted, or what was the bottom line from these couple of years of work?
I don't have that information with me. I can follow up with folks at the Vermont State Housing Authority to see, there may be a report that I can pick up as well, but I'll take a look at that.
They were appropriated 2.5 million in fiscal year 25 in Act 181.
I'm going to pause you for a second. We have a lot of new people who come in. You're all welcome to stay. If you're here for age 7:40, it'll be at least 11:30, if not a little later beforehand. Again, you're welcome to stay, but if that's what you're waiting for, it's going to be a little bit. Okay? Thanks. All right. John?
Just a quick question. So, just as a follow-up to Representative Stevens' question about adding to the number of homeless may result in here at some point in time. And you said it wouldn't change the number. Do we know what the number of proceedings are related to what's being looked at? And I don't need an exact number here, and we can talk later about this if you need to look back a little bit. That's fine.
I would have to
Just curious, that's all.
dig through my emails to pull a number and rather than y'all watching me dig. through my
And maybe
emails.
somebody, that would be good if you can get back and judiciary might know. Yeah.
I think it's an important question. Stephen.
Okay. All right. Yes, go ahead,
I
Cameron.
can answer a question, at least my belief that was raised by a ranking member. I did a quick search through the bill that came out of House General. I don't have a concern with the definition or the use of a participant property owner. That term is used in the credit reporting pilot program language. It talks about participant property owner, but then it's defined as a landlord. So unless the treasurer's office raised a concern, which we didn't discuss last year, I don't have an issue with the use of that word in that pilot program.
So if your change helps.
It's just the participant property owner is then defined as a landlord, and I could pull up the definition. That would be helpful. But there isn't a legal concern of using that term in the pilot program language.
Dave?
I want to make sure I'm understanding this correctly, and thanks for your patience, but could you just walk through an example so that I can understand that no ejection or non-payment? So you get 3 notices? Could you help me?
So the current statute in sub A, and I'm trying to go up pages. Give me a second, I'm just wanting to be able to share my
Sure,
screen
sure.
again.
Oh.
Not sharing.
I would love not to share. Somebody else.
So in the sub A current statute, a landlord can terminate a rental agreement for non-payment of rent. So if you do not pay, the landlord can terminate.
Anytime, I'm after that 10-day window?
So that's what I was about to get to. The
Sorry.
statute, no, that's okay. The statute does not state how long a landlord has to wait.
Okay,
So conceivably, if rent is due on the first of the month and there's a separate statutory section that says rent is due when it's due and laptop died. Rent is due when it's due and the landlord isn't obligated to request it. Like rent is due without, demand. And so if rent is due on the first and you're not paying it, the current statutory section says non-payment of rent, and it doesn't require there to be any time frame between 1 and 2. So in theory, the second or third day after you haven't paid, a landlord could terminate your rental agreement. Now, practically, I imagine the landlord isn't interested in that because they simply want you to pay. They don't want to have to go through the termination and the ejectment process. Within that subsection A, under the current statutory language, it says that even if the landlord provides a termination notice due to non-payment of rent, if the tenant subsequently pays rent for that rental period, it negates the termination notice. So if I'm terminating your rental agreement because you haven't paid rent, then you pay rent, it negates my notice for that rental period.
how quickly do I have to pay rent?
Doesn't
in order
say.
Under the bill?
It doesn't say under the current statutory language.
Okay. So under the bill
So,
proposed,
So landlord can terminate the tenancy for non-payment of rent. The rental agreement shall not terminate if the tenant pays or tenders rent due through the end of the rental period. And there's no,
What's the rental period?
could be a month, could be a week. It depends on your rental agreement.
Okay.
Okay, and so the discussion among the committee was, well, what do you do in the event that you have some sort of habitual late payment circumstance? One could argue that under the B1 current statute, it says that a landlord may terminate for failure to comply with the material term of the rental agreement. If I'm a landlord, I would probably move forward with that. And I would say your continued late payment of rent is breaching a material term of the rental agreement, which requires you to pay on time. But there was question among the committee about whether that was sufficient. So the committee wanted to put in plain language that continued late payment of rent is a breach of the rental agreement that a landlord can terminate the agreement for. And so then there was discussion about, well, how many times, if it's late payment, if it was originally drafted as repeated late payment of rent, and there was a question about, well, what does repeated mean? And so there was also a question about, well, how late does the payment need to be? Do we really want to authorize termination because somebody is late one day a few times? So the committee landed on this language, which is if the tenant is late 3 times within a 12-month period, and late is defined as paying more than 10 days after it's due. Late payment of rent means payment of rent more than 10 days after it's due. So if you're late more than 10 days, 3 times, then the statutory language proposal would allow a landlord to move forward with the termination of a rental agreement, despite what subsection A says.
Thank you.
Yes, sir.
Okay, I'm going to pause this for a second and let everybody know we've had to reschedule H740. Clearly, we're not done with this yet. I'm sorry. It's going to be probably at 2 o'clock. Daryl will let you know, but I think that's what we're looking for is 2 o'clock this afternoon. Again, everybody is welcome to stay, but I just wanted to update you because I have a feeling a lot of you are here for the next bill, and we're going to postpone until 2 o'clock so we can finish this bill. Okay, all right. Thank you. Let's continue. Do you have more questions for Budget Council or Joint Fiscal at this point? Because I will also have Chair Mahali come up. You guys don't have to leave. You can just add a third chair or however you'd like to do that. But let's get Mark, you up here. Get another chair.
I do have to run with.
Okay, well, I think we have what we need from you, and I think you're getting a couple things back for us, and then we appreciate your time, Ted, and we'll have Mark take your place.
All right, sounds great.
Thank you.
I'll stay with you if that's okay.
I would love
Okay.
You can correct me.
I would never present to you, so.
I'm passing around Mark Mahali, Chair of General and Housing. Thank you. It's wonderful to be back in this room with you. What I'm passing around is simply a one-pager. And I do want to say procedurally one thing. Judiciary is in the midst, the final stages of a flyby. And their chair has been working very hard. We worked together over the weekend. I think their work so far is actually improving the bill in many respects. Really done a wonderful job. What I passed around reflects actually our version of the bill as modified by judiciary to date. The remaining issue is one you heard from JFO, which is that the courts have come to judiciary and said, we need an extra $700,000, which we don't have. And so what are we going to do about that? And that's what is sort of hanging out there. How is that dealt with? And so when you hear Martin Lalonde, Representative Lalonde, that will clarify. But up to this minute, this list, I guess I want to start by saying,
this was a rather difficult effort. In part because of some real realities that are out there. The reality is that having a home is really fundamental to happiness and living a life. And we have a problem in Vermont that when people lose their home, they're very likely to become homeless. And that homelessness has fiscal impacts in addition to its immorality. It has fiscal impacts because people end up in the motel program, or you are very well aware of the high cost of homelessness. So that's a reality. The other reality is that we provide housing largely through the private sector. And they run business. A landlord is running a business. The business has to work. If the business doesn't work, the landlord goes out of business. We have the tenant advocates on one side, landlords on the other, with pretty incompatible visions of how to deal with this problem, which, was something we had to deal with. There are, as Tom mentioned, there's a real concern on the part of tenants that if we make it easier to have ejections, then we're going to have more homeless. We have no way of knowing whether that's the case or it's not. Landlords are filled. We were inundated with stories of landlords who have very marginal operations and would feel that they couldn't invest, couldn't stay in the business, or would leave the business or go with short-term rentals if they didn't have some relief from the current situation. And the current situation, the landlord side, has two elements to it. One is it takes approximately 6 months without a jury trial to evict someone in this state. In many other states, we are an outlier in that respect. In many other states, it is a third that time. I mean, we really are an outlier in that sense. The other major problem from the landlord perspective, which you saw our attempt to deal with it in the walkthrough, is many landlords, including the nonprofit landlords, have a real problem that they have tenants who are dealing drugs or engaged in other dangerous activity in their buildings. It may be the tenant, but it also may be a former tenant who comes back, or it may be someone who's related or a friend of the tenant who comes back, or worse, it may be someone who makes it clear to a tenant that they will harm them if they don't let them in so they can deal drugs. And so and also we heard many stories of tenants who are destroying units. The problem when you're dealing with something like this is you have bad landlords and you have bad tenants, but you have the bulk of landlords are good landlords, and the bulk of tenants are great tenants. So how do you pass legislation that deals with the bad cases without making life difficult for everybody else? That's the problem we face. We tried to avoid this no cause, just cause, all these labels, because they are inflammatory. And actually, when you look at them in many states, they are filled with exceptions. So what we did is just deal with each case one at a time. So I conceptually, and I'm going to be conceptual because it helps, perhaps helps you think about this issue. We see two baskets. One basket is where the tenant is the moving party, the cause. It may not be their fault. Forget fault. They're the cause. They can't or aren't going to pay rent. Which in many cases, remember, Vermont is filled with small landlords. Their business is marginal, and it doesn't take much for them to go under or not be able to make their mortgage. Okay, that's one, non-payment of rent. A lot of the evictions are for non-payment of rent, and a lot of those people end up homeless, and a lot of those are it's not their fault, they just don't have money. Okay. The second is the dangerous tenant, the one I alluded to. So that's the tenant basket. The other basket is what I'll call the landlord basket. This is where the landlord is really in control and can plan. This is where the landlord is saying, your lease is up and I don't want to renew, or I want my family to occupy this unit, or I want to convert it to a condominium, or I want to completely remodel it, so you got to leave, or I want to sell it. I mean, it's the landlord's kind of initiative. When it's the landlord's initiative, we felt, what can we do for tenants in that situation? What we did not do, to be clear, and certainly many tenant advocates would like, is we do not put rent control, rent caps, a right to stay in the unit forever as long as you pay rent. Things like that is not in this bill. There are 3 states in the United States and some cities that have some version of that. Although I will tell you, I've read their ordinances and some of them are filled with exemptions, but they're not in the bill. What we're saying is, so what did we do? These are situations where the landlord is in control and the tenant may be perfectly innocent. 1, 3 months notice. You have to give 3 months notice. So that's 1. 2, you have. Representative Wood had a bill that said that security deposits should be 3 months. Some people argued 1 month. We settled it 2. Whatever it is, as Tom pointed out, it's a lot of money. So we said halfway through that 3-month period, the landlord's got to do a walkthrough, and if there's no damage, they got to return half the security deposit. And the reason for that is to give people at least something to be able to have in their pockets so they can put a security deposit on the next unit. We also, so those are kind of in summary what we're doing with when the landlord is in control. Longer notice periods, a requirement of a 90 days, et cetera. When it's a situation where it's non-payment of rent, that's really the most difficult because so many people are just, I was a legal aid attorney when I was young, and I can tell you most of the people who came to me, it was some version of, I don't have any money, how long have I got? And the best, we did a few things in those situations, but do not pretend, I do not pretend that we've done a wonderful job of it. I don't know how to do a wonderful job given the way our society is constructed, but here's what we did. First of all, the 10-day grace period. You know, a lot of particularly institutional landlords, if you don't pay on day 1, as a protective matter, they file a notice of termination. Now they can't. It's a 10-day grace period. The second thing we did is a code defense. If there is, and this is true in Massachusetts, it was actually suggested to me by legal aid, and I think it's a good idea. Basically, if there's a code violation, I don't mean a technical code, I mean a really serious code violation that is uncured by the landlord before ejectment is filed, not after, but before. It's a total defense to the ejectment. And we're just trying to deal with landlords who are just not, again, the bad landlord, not the good landlord. But the biggest thing we can do for them is the stuff that you saw on the board of the JFO. Unfortunately, when we looked at the appropriations in this bill, and on your 1 page, they're in bold. The Rental Arrears Assistance Fund is a really efficient way of doing things. The Rental Arrears Assistance Fund, again, is not aimed at somebody who's never going to pay rent or is destroying the unit. In order to qualify for the Rental Arrears Assistance Fund, you have to be able to demonstrate that you can make rent. It's just something bad has happened to you, like you got sick, or you have a problem with your car, or something very specific that's short-term rather than long-term. And then the fund, I think, can provide up to 3 months rent, and it goes directly to the landlord. So this program is really an excellent program. Lynn, you asked
wanted to know the
results.
data.
And, I think Kathleen Burke probably could get those to you, but we had testimony that it's very effective. And anything that can be done like that with a small injection of money, I mean, I know $1 million isn't small, but the individual small injection of money, keeping someone off from living in their car is worth, in my mind, it's a multiplier effect financially. It means that we don't have them in motel rooms, et cetera. I think the credit reporting thing is wonderful. I hate to admit, but I do not believe it was the $100,000, Madam Chair. I think it was, we forgot. There were two bills, one House bill in the Senate bill in the House. Then we had a conference committee. It was lost. It just got, I cannot find what happened to it. I'm sorry, but it passed, it passed both houses. I cannot recall, and, I can go back through my notes, but it's passed both houses. I think it's a great idea. And the very simple reason is, and I didn't know this, paying rent is not automatically reported to credit agencies. It's just not on your credit report, which means that people who don't have credit cards or don't have, a lot of assets have no rental history, no credit history. So this is an attempt to build credit history, again, aimed at the good tenant. At the bottom, where it says for both tenants and landlords, the CBOEO, we were looking for education. Again, this is preventative. We are looking for education for both landlords and tenants on their rights, their responsibilities, and their remedies. And CBO volunteered they could do this. And the 600,000 puts representatives in the CAP agencies who work with landlords and tenants for mediation purposes. It's all prevention. On the theory that prevention is much less expensive for the state than homelessness.
So let's pause on that one for a minute.
Yes.
Because I'm back to base versus one time.
It's all one time.
So they would hire some people for a little bit
I
of time.
think they have,
go away? Because we don't have base, so
No, I know we don't.
they understand that this.
It have to be, if they're, to the extent they're state employees, of the limited service, to the extent that it's private nonprofit or the CAP agencies, they'd know this is your shot this year. Can I say that you won't have people back asking for it again? Sure, of course.
Know that.
But I assume none of this is base. It can't be.
Yeah, okay. Lynn?
My understanding is that there have been, I don't know who was run by the OEOs or the legal aid or something, but there have been pamphlets, materials that did this already, that gave tenants' rights, handed out to people.
Right, there are. And there still are.
And there still are.
But they're not, we felt that human beings on the ground who could, there's a demand for, again, I'm talking about conscientious landlords and thoughtful tenants. And these programs are aimed at keeping them from being homeless. From the landlord perspective, there are two aspects that you heard that really matter in this bill. And this is from their perspective. One is we tried to shorten the overall time. There's a provision in the bill that says that right now it's 6 months. The courts have testified they aim for 6 months and 80% of the cases are resolved in 6 months. Right now. We tried to shorten the time. There's a provision of the bill that says from the time you file to the time of the hearing has to be 60 days. The courts are saying, well, that's going to be very expensive. We're just going to see how we deal with it. But in some ways, more important than that is dealing right now. I am just hearing terrible stories about the effect on housing supply of tenants who are dangerous. We just got, I think I forwarded it to the committee. We just got, for example, a letter from Brattleboro, I think it was Brattleboro, a 20-unit program run by a nonprofit there for homeless, where they just took it offline because there was crime, drugs, they couldn't deal with it.
And it's very, I feel, after hearing a lot of testimony, 20 witnesses and dozens of letters, that the problem of the tenant who is violating the law or engaged in activities that's dangerous to the health or safety of others is going to decrease the supply of affordable housing over time because landlords will not stay in the business. I cannot document that. There is no way, we do not have data any more than I can document that this bill will cause an increase in evictions. We don't have data in Vermont. We have stories. And that's what you hear. It's just life in the legislature. So what we've tried to do is create a special process that says, if a landlord has a tenant that is doing drugs, for example, in the building, selling drugs, or something like that, when they file a complaint and eject, first of all, they will give a notice of termination. It's 5 days. When they file a notice of ejectment, they file an affidavit, a sworn under penalty of perjury that says, I think you're dealing drugs and here's my support for that. And then there has to be a hearing within 21 days and 10, minimum of 10, a maximum of 21. And either the tenant doesn't show up, in which case then it's a default and the possession goes to the landlord, or the tenant shows up and there's a hearing on whether it's true or it isn't true. And that was the best we could do.
Wayne has a question.
Comments. Actually, I didn't ask a lot of questions because I was on AI looking at all this stuff. And so,
AI is not always the truth. Let's just remember
it
that.
is when you're looking at the bill, that's fully interpreted. So what I want to say is that I think this is a really good job. I think that, what you were trying to do and accomplish is good. And what you were just saying there at the end, I mean, I think you can contribute to homelessness both ways. And not to forget that if these landlords are going out of business because the hassle of being a landlord is too much and they go out of business, it's going to contribute just as much to homelessness if it works the other way. So I think everybody should, that's a point that could be made that might back those off that want to push one way or the other on this. And I just hope you just map things up too much. We try to fix it. I have to say, there are times when you have a compromise and everybody doesn't like it and you still feel good. This is not one of those times. It's just a dark situation because the question is, do you hurt homelessness by increasing the number of evictions? Or do you hurt homelessness by decreasing the number of apartment units that are available? I mean, it's not a good situation. And this bill is our best attempt at a kind of steering a middle ground here. And I think I'm not going to, Madam Chair, unless you so desire, I'm not going to go through this list.
No, I think this is helpful to have everybody. I know we have a question from Rep. Maricki.
Well, I just wanted to update on the Brattleboro situation. Those units were not taken offline. They were converted. They were supported housing where every tenant had a caseworker. And because of the level of crime, including a murder, the organizations decided they could not continue that level of support. So they're suddenly rented.
And rented for people who are low and moderate income.
Yeah.
They still will be. They just won't be for homeless, I think.
For homeless.
Yeah. They wrote a letter. Who was that? Elizabeth Bridgewater? Yeah, wrote a letter in support of this legislation because of that. I would say that the tenant who is dangerous or engaged in dangerous activity, I will say, I want to be fair about this. There is a concern, and one of the problems with this whole area, it's not like anybody's making things up and their concerns aren't real. All the concerns are real. There is a concern that this could be subject to abuse. The landlord doesn't like somebody and they say they're dangerous, or somebody's
just not a very nice person, but you know, they're not really a danger. And I guess all I can say is, yeah, so there'll be a hearing. And we're leaving it to a court. I don't know a way around that.
Dave?
Could you imagine I wanted to talk a little bit about the request for 600,000 to have staff who can help people sort through this. Could you imagine our current human services workers at the parent-child centers, at Community Action, at other organizations, as a condition of the grants they get to do their baseline work they do today, something along the lines of you'll be required to attend a 1 or 2 day workshop to learn this, so that current clients you work with who trust you, who have a good relationship with you, can get this service, as opposed to new people starting it all over again? Or am I being naive, or is it just not likely that people can master this in addition to their other duties?
Well, no. I think that, first of all, you mentioned the parent-child centers and run, you know, under the CAP agencies. That's where these people would be. In fact, I think 2 in Burlington and 1 in each of the others. And the feeling was that you needed new positions. Could we add it to the work of the existing staff of the CAP agencies? I don't know. I think they're probably pretty overworked. But I can't answer that question.
Thank you. No, it's okay.
Okay, I am not seeing other questions. As you know, we have more to come on this, but I think we have a good grounding in what this is. I know your committee's done a lot of work on this, Mark. So we thank you for that.
Sure. It was a pleasure, always.
Always nice to see you back here. Chair Lalonde will be in here Wednesday morning. He will have had his conversations on the judiciary side and will be back. And so that's
An example, I just gonna give you an example. For example, we shortened the answer time. Originally, in the very first draft of the bill, it was 7 days to file an answer. We heard testimony that it takes sometimes 5 days for people just to get it, read it, understand it, and get to somebody much. And so we extended that to 10. Martin said, we don't want a different answer period for this and everything else in the civil docket, so it's 21 days. So that lengthens the time a little, but the notice periods, remember council talked to you about, there's periods for by which a landlord can say, your lease is done, you're done. A notice of termination. And then if you don't leave, then they file the ejectment action. So on the notice of termination, what we did is we shortened it by 4 days for non-payment of rent. We shortened it a lot for an allegation of violence and dangerous activity. But for everything else, we lengthened it to 90 days. For the reasons, remember the 2 baskets for the reasons I described. That's not changed. Most of the stuff that's changed in the judiciary language so far is, I think, really good. Bringing it to in conformance with the current code.
So we'll hear that on Wednesday. We need to vote it out before Friday. So I don't know what day, you know, we'll just see how things go with that. So I want to thank you all for the time we spend. And committee, I need to give you a few updates that don't have anything to do with this. You know, this is that time of year, so we're going to continue to change. We'll text you as we need to. For now, we've moved H740 to 2 p.m. this afternoon. And then we are looking to move H660, which is the opioid bill, till tomorrow morning, because Tiff still has some things to do and people to talk to about a couple of things that we haven't been able to get to. And we want to be able to look at it and vote. So, and we don't want to waste time. So you all have priority things to work on. The rule on that is you can't leave Friday without handing that into James. Okay. So if you're done at 9 AM, well, you should go to the floor, but or he's hoping that he'll have them all by evening time because it's Friday. We're still live, so we'll keep the noise down. But that's the plan, is to get it in. But yes, if you would also, yeah, you can email and or handwriting that he can read. Or you're gonna get lots of phone calls over the weekend. And you remember, 5 million, 5, 0 to 5, 5 to 10, 10 to 15. Go ahead, Marty.
So I have a question. I presume then we'll submit this and James is going to say, well, there are 3 votes for this one and 5 votes for this one and 6 votes. You're gonna try to group them together and figure out which ones rise to the top based on.
Well, we're gonna
How
talk
are we
about
gonna
that,
do
yeah.
that?
So what we did last time was we took everybody, James and I, well, Maria and I knew who everybody's names were, but we didn't say who everybody was. And we gave everybody sort of a list of what people were talking about so we could see that. And then but I think we don't have to do that step because now we're asking you to prioritize first thing. Last year, we didn't ask you to actually prioritize until the second step. You're prioritizing now. So we can do something like that that says, here's what everybody's tier was and maybe how many there were for each of those. And we'll have a conversation about it, obviously. We won't just look at it, or I won't just look at it and say, okay, there we are. So we'll talk about it.
Okay,
Monday.
but I
Yes.
presume the idea is to gather, there's a lot of support for this idea, but
Right.
not so much for that.
That's
idea.
right.
And,
right.
among the group, the
Yeah.
main items seem to be these 10 items.
Right, and so we'll observe all those things and then, but if, maybe you're the only one who picked whatever.
Flood relief and the NEK.
Yeah, well, there you go, right. Although I can tell you there's,
There's a couple of.
right, but maybe you're the only one who picked, something in particular. You still get to make your case to the group, and so maybe you'll change some minds, right? So maybe
That
we'll
happened
hear.
last year a little bit.
Yeah, it did happen, and so it's gonna be kind of fluid, but we'll be, we can see that there are 6 for this, and so maybe some are easy yeses, and then some others we're gonna struggle with, and then people get to make their case, and we'll wait and think about it and come back.
Yes, I just want to ask, I think I can do this, but I just want to double check. If we decide that we have a request for $1 million and we say, no, we'll only give them 500, we can indicate that.
Absolutely. Absolutely. You don't have to give the full amount, right? And we've done that before. We say, we know some places want 2 positions. Well, maybe 1 position is really all we can think about, but we really need that 1 position. So
Want to
absolutely.
double check.
And if you're gonna do something extreme with one of these, you might want to find out if at what point it's so it's not what you're doing. Because sometimes there's that too. But it isn't, most of the time, it's not all or nothing. Most of the time, something is okay. Yeah. But, and then I'll be around for questions. I'm trying to give you time today to do stuff. Since if we're just gonna start at 2, then that's the only bill we're gonna have this afternoon. So we've got time for people to work on it. I've got to do mine too, but I'm happy to answer questions. Some of you said, I want to talk to you about what I'm thinking about, so.
Can we have bills up for the roll calls up?
Oh, yes, there may be a roll call on at least 1 bill today, I think.
If we,
849? Yeah, Dave?
if we believe a particular priority item is likely to have serious consideration from the new rural health transportation grant,
Yeah,
do we just omit it and assume, well, that'll go that way? Or do we flag it with a asterisk?
I would say talk to me or even better, talk to Nolan.
Okay.
Yeah.
About it's likely.
Yes.
About whether to
Yes,
Yeah.
yes,
leave it or not. Yeah.
right. Right.
Thank you.
Yeah, I think he's the main man for that one.
Is he here?
No.
Well, he was here.
He would love to hear that he was the main man.
Yeah. Well, it's now, put it up as much as often as he wants on our live stream. All right, so I think we're gonna be on at 2 o'clock, and you've got time to start working. Let's go